cause number CATX 2000-002. Mr. John and Ms. Case have identified themselves. Council, we have discussed this matter in conference this morning. We are familiar with the record. I'd ask that you keep that in mind when you present your argument. Because this is being recorded, I would ask that you identify yourselves again before you start your argument. The appellants are reminded that if you want to reserve time for rebuttal, that is up to you. You just need to do that. Our bailiff will identify when there is 5 minutes remaining in your argument and 2 minutes remaining in the argument. And with that information, Council, you may begin.
Good morning. Thank you, Ron. May it please the court, my name is Douglas John. I'm here on behalf of SWAT training facilities. Throughout the oral argument, I'll refer to SWAT training facilities as Shooters World. That's the name they do business under. Both parties agree this is a case of statutory interpretation. In particular, whether Shooters World operations of a shooting range falls under the amusement classification under 425073. The amusement statute seeks to tax two types of economic activity. Those activities where you pay an admission fee for spectator events such as movies, theaters, sporting events, and those activities where you pay a fee to use a facility to perform or participate in an activity. Those are referred to as participatory activities. Examples of participatory activities include such things as tennis courts, bowling alleys, skating rinks, video arcades. Operating a shooting range is not specifically enumerated in the amusement statute. Instead, the department seeks to tax Shooters World business under the general clause of the amusement classification, which imposes a tax on, quote, any other business charging admission or user fees for exhibition, amusement, or entertainment. Thus, this raises the question of whether the shooting range is of the same kind or nature as those activities specifically enumerated in the amusement statute. In Wilderness World, the Supreme Court provided guidance on how to distinguish between those participatory activities that are taxable and those that are not. The court characterized taxable participatory activities as those requiring no supervision. This makes sense and is consistent with the amusement statute. When you pay a fee, the fee is for the use of the facility, whether it's to bowl or to play pool or to play video games. You're paying for use of the facility. That's why the Supreme Court emphasized that the activity had no supervision. In other words, the activity does not require someone to oversee that activity. Operating a shooting range is not like the enumerated participatory activities in the amusement statute. It requires a substantial amount of supervision of people who patronize Shooters World. First of all, what sets it apart is that under state law, you cannot operate an indoor
Council, many of the enumerated categories in the statute do require some supervision.
Some supervision, maybe, but I think it's not what the court in Wilderness World meant by supervision.
But Wilderness, not this case. I mean, not to phrase, but in Wilderness World, we're talking about a trip that lasts 2 weeks. Right? A river trip.
Judge McCurdy, you cut in and out. I didn't hear your full response. I apologize.
Wilderness World is not this case. I mean, Wilderness World involved what, a 2-week river rafting case?
That is correct, but we're talking about specifically the level of supervision that's being provided. And at the time that
there was some supervision even in Wilderness World, wasn't there?
Yes, and that's what set it apart. The guides, in fact, provided a great deal of supervision to the patrons as they went down the river. Now, there were other things that were provided within the fee or the charge in Wilderness World, but it was the level of supervision. So if you look at what supervision is defined as under Merriam-Webster's. To supervise is to be in charge of, to superintend, or to oversee. When you go to a bowling alley or video game arcade, for example, the staff are not superintending or overseeing you while you're participating in the activity. So my point is that it really was not the supervision that is taking place, or well, if you want to call it supervision that's taking place at these things, is not the type of supervision that the court was talking about in Wilderness World.
So a police officer that goes to do some target practicing at this location, how much supervision does he or she really need?
That would depend. As the record shows, that through any person who goes to Shooters World is constantly monitored, both by the range safety officers when they're on the range, as well as by closed circuit monitors. And as well as the record showed that the owner, Mr. Rue, testified that it didn't matter what the level of experience was. Everybody that goes to Shooters World is monitored. They make mistakes. They have to be monitored all the time. In addition to being monitored, there is the part about the instruction that is discussed. So if you're being monitored and someone makes a mistake in loading, for instance, your gun, though, there is an instruction part of it. So the person is not only is it pointed out to the person that they're misloading the gun, but the range safety officers at Shooters World shows them how to correctly load the gun.
Mr. John, let me interrupt for a second. I apologize. I think we understand that the building in Wilderness World is at one end of the spectrum here of the analysis. What we're trying to understand, I think, and define are the parameters of the classification. I mean, in this case, it seems like the client, there's a significant percentage of the participants who attend and participate at Shooters World merely for the entertainment offered by that experience for a number of hours. The degree of supervision seems to wildly vary. I think the constant is a monitoring feature. And that's part of the business model that's probably imposed by government regulation. The instruction piece that you were starting to talk about seems to me that this is a situation where the taxpayer clearly could have structured its business in such a way that a fee associated with that type of hands-on instruction could be characterized as a non-taxable service. So I'm not so sure that this case is as black and white as you and your client have portrayed it, which makes it a difficult case, I think, for us to try and again set the other side of the parameter from Wilderness World. Maybe you could comment briefly on that.
Yeah, Judge Winthrop, I think you're right. I don't think that I believe you're right. On the spectrum, we're not Wilderness World. We've never claimed that we were Wilderness World at all. And you're right, this is much more somewhere on the spectrum closer to those activities listed in the amusement statute, but it's not that. The instruction part is not just inconsequential. The record shows that, in fact, Mr. Hansen, as the general manager, stated, and both the briefs quote this, stated that anytime between 70 and 80% of the patrons are receiving some kind of instruction. And there are formal classes that you can take. There's a number of classes you can take at Shooters World. You can pay for them. They're non-taxable, all that. I think our point is that as a part of the experience, the range safety officers provide both a monitoring component to it, but there's also an instructional component to it. In other words, they're part of the entire experience that any patron goes there. Now, yes, some patrons that go there don't require as much well, they all require the same amount of monitoring, but they don't require as much as instruction. That is certainly the case. But if you look at Wilderness World and you look at its description of what the guides did, and again, I'm not claiming in any sense that the experience at the Wilderness World experience is like our experience, but the experience at what the guides did in Wilderness World is not all that different. I'm looking for the description of it. Yeah, here's what the description is that in Wilderness World. This is the facts that were laid out in the case. Professional river guides and employees conduct the river trips and provide first aid if necessary. Range safety officers, in this sense, we have specially trained persons that monitor the entire experience from start to finish. And they're all trained in first aid. In fact, they're all trained to handle catastrophic events, which of course could happen in such an environment. Goes on, a typical river trip was guided by a lead. Again, range safety officers are there to guide you while you're on the shooting range. The lead was required to have a bachelor's degree and several years experience guiding river trips. Our range safety officers are all trained. They all have extensive experience, usually either in the military or as peace officers previously. That you would not, none of those characteristics you would see at a bowling alley or many of the other enumerated activities. In addition,
what about a batting cage?
With regard to what?
Well, it seems to me that, and not to draw on my own personal experiences, but going to a batting cage where you've got a ball coming in at 100 miles an hour, you have almost exactly everything you described. You have constant monitoring by the people that are there. You have, I'm sure they're involved in first aid. They're able to give it on-the-fly instruction if they see somebody not complying with the rules and safety regulations of the batting cage. And yet it's an enumerated event under the statute, isn't it?
And I wanted to kind of piggyback on that. I mean, certainly the statute lays out things like, you know, operating a jukebox, where no one would really argue that any of those things come into play. But when you think about going to a batting cage, or even more so, an amusement park where you've got rides going 60 miles an hour, where every single patron is instructed when they sit in a seat of a ride, if they're being monitored all the time for safety. If someone's standing up on a ride, the ride has to stop. There are things that malfunction. There are safety issues. So even in the statute, there's a wide spectrum. And I think back to Judge Winthrop's point is, where do you fall? Because where do you fall? How do you fall so far outside of an amusement park, for instance, and not get to Wilderness World? Is there anything in between?
Yeah, I believe that there is, and I believe we fall there. Again, we're providing all the monitoring and the instruction that goes along with it. There's none of that at amusement park, as far as the instruction that goes with it. There's
but it's the instruction to use the facility. You're being instructed at an amusement park that you're to sit here, you're to put your feet here, you have the bar down here, you can't stand up, you can't rock this boat. I mean, there's lots of instruction because we don't ride amusements without supervision. You never get on a ride where there's not somebody standing there operating it, instructing you, stopping things when things go wrong. I mean, how is it so different from an amusement park ride?
Well, the people, for a number of reasons, the people at amusement park are not special. For instance, they're not specially trained in how to ride the ride. Again,
oh, excuse me, are you kidding? You don't think you don't think the person who's telling me where I can sit, where I can stand, hasn't had some training or experience on how to do that, or they just do that on the fly?
No, I just don't believe it's the same level of training and experience necessarily that you have with the range safety officers at Shooters World. It's not the same. I think that you not only have have a higher level of training, but you also have, it's a much more dangerous environment than you have at these types of events. And so they're specially trained. They provide instruction constantly throughout the event, or throughout the activity, both monitoring and through instruction. I think I'm going to stop now and reserve the remainder of my time for rebuttal.
All right, Travis, how much time does he have in rebuttal? Travis?
5 minutes and 42 seconds.
All right, thank you. Counsel?
May it please the court, my name is Nancy Case, and I represent the Department of Revenue. The main issue in this case is whether Shooters World's hourly fees to use its target practice lanes were taxable under the amusement classification. Target practice lanes fit under the amusement classification under the plain language of the statute. Any business charging admission or user fees for amusements is taxable. Here, customers pay a fee for 1 hour admission to the target practice lane. And shooting lanes are an amusement like the enumerated businesses in the classification. Tennis courts, bowling alleys, skating rinks, pool parlors are all enumerated businesses. They have common threads with target practice lanes. There's participatory activity. Customers pay an admission fee to do the activity at a specific facility. They often pay admission for a set amount of time. These are skill-based sports requiring practice. Customers come in to improve a skill or just for fun, and they're specialized to participate. There are rules for safety, and there's monitoring to ensure compliance with the rules. Wilderness World supports the department's position that target practice lanes are taxable. In that case, the Supreme Court looked at the plain language of the statute. Was it an admission fee for amusement? They determined that it was not an admission fee. They then looked at, was it the same kind or nature of activity as enumerated businesses? And in looking at skating rinks and pool parlors and tennis courts and bowling alleys, they determined that it was not. None of the enumerated businesses resemble a river trip, an expedition of extended duration covering hundreds of miles. That's why it wasn't included in the amusement classification. The Supreme Court did not exclude the rafting trip because of instruction or supervision. Supervision is in fact mentioned only one time in the entire opinion. That's when
Counsel, you cut out for a moment. Could you repeat? You cut out for a moment. Could you repeat what you just said about 10 seconds ago? Or
okay, I may back up a little bit more just to make sure you get every word in. They looked at whether the rafting trip was the same nature or kind of activity as the other enumerated categories. And they said, no, none of the enumerated businesses resemble a river trip, an expedition of extended duration covering hundreds of miles. The Supreme Court did not exclude the rafting trip because of instruction or supervision. Supervision is mentioned only once in the entire opinion. And that's when the Supreme Court generally characterized enumerated activities as mainly spectator events or participatory activities requiring no supervision. Mainly, not the only things that are taxable. And some amusement and some enumerated businesses do have supervision. The amusement parks mentioned earlier, they hire ride operators. They ensure that the bar is down and that you're not getting on with a selfie stick and that fingers are inside. There's just no exception for activities which have supervision or monitoring or are dangerous in some way. The range safety officer monitors the lanes for trip hazards, working fire extinguishers and flashlights, and customer compliance with the rules. And what are these rules? Don't shoot the floor, no food or drink, point the gun downwards. And actually, we do not know how many range safety officers there are. In Wilderness World, there was a rafting guide for every 4 customers. Here, there's no record of the ratio of safety range officers to customers. We do know that military and police officers supply their own range safety officers, so Shooters World doesn't do that. Their monitoring protects their property and lessens their liability. And shooting ranges in general have a range of supervisions. There's no evidence of what level of supervision happens with shooting ranges outside of metropolitan areas. The admission fee is not a fee for instruction. 20 to 30% of all Shooters World customers receive no instruction on loading or operating the firearm. This is because many of them are repeat customers and many of them are bringing their own guns. The range safety officer never acts as an instructor because their focus is on safety. Shooters World did offer classes, but the department didn't tax classes. And other than classes, much of the instruction on loading and operating and how to grip it and how to fit it in your hand happens with the rental customers. And rental is a separate fee. It's not part of the admission fee. Rental takes place at the counter before the 1 hour admission starts. But even if they were doing some kind of instruction, it's still taxable. To separate out businesses that do both amusement and instruction, they have to separate that in their books and records. 42507E. And there's a $15 admission fee, and there's no record of Shooters World separating part of that out for instruction and part of that out for amusements. And if there's no further questions on the shooting range admission, I would like to move on to club memberships. Memberships, the secondary issue, memberships include retail benefits. People who bought Shooters World memberships got free merchandise, discounts on retail purchases, members-only sales, and free or discounted firearms rentals that encourage customers to try various firearms, all of which were available for sale. And the rentals, this court held that a service provided to encourage members to buy merchandise is included in the gross income of the retail business. It was a retail sale, but regardless of whether you put it in the amusement classification or you put it in the retail classification, there's no difference. In closing, admission fees for Shooters World are taxable under the amusement classification because customers pay the target practice lanes. And shooting ranges are an amusement like the enumerated businesses. Club membership fees include retail benefits, so they are taxable under the retail classification. We ask that you uphold the tax court judgment that admission fees are taxable under the amusement classification and club membership fees are taxable under the retail classification. Thank you.
Are there any additional questions for her as it relates to either of those issues?
I don't.
All right. Thank you.
Thank you.
Mr. John, before you start, in your rebuttal time, could you address or distinguish your client's situation from the fees charged by folks running skydiving services, parasailing, rock climbing, even the Bondurant driving school revenues? I mean, these seem to be analogous to, arguably, to groups of businesses identified in the statute and with significant crossover to the way your client conducts its business.
And I believe you're on mute, counsel.
There we go.
Of course, this won't be document time.
That's fine. First, I don't know the specifics about how those businesses operate. And I don't know whether they are taxable or not taxable. All I know is what the record states with regard to Shooters World. And so somewhat factually, I think these are heavily factual determinations as to whether they're taxable. Some of them may be paying tax, and maybe they should not be paying tax. I think if you skydive and someone skydives, well, I've seen the pictures of it where they're skydiving with you. They're certainly a part of the activity that's going on. They're holding you as you're going down. They're certainly part of the activity, and to me, that would be certainly qualify as an instance where they're being supervised or overseen or superintended. So I think it'd be questionable whether those would be taxable. The other ones, I don't know the specifics again of how those businesses operate.
Counsel, is there a general test that you could craft that would encompass what you're talking about? You say it's a kind of a case-by-case factual basis, but how do we do that?
Well, I think that's what the court was trying to get at in Wilderness World. Again, what the statute is trying to tax is an admission fee or a user fee. In this case, a user fee to use the facility. When there are a substantial amount of service in addition to the user fee, that's where I think it crosses into the area of not being taxable. Again, taxing statutes just—
Okay, well, but that's my point. So you say substantial, 20%, 30%, 60%, 80%. I guess, what does substantial mean?
Well, again, I don't know what substantial means. I don't know exactly what the test would be. The way the court related out was that there was no supervision. That's kind of a black and white test. I'm not asking you to adopt that, but I'm saying that's what the court had said. And if you look at taxing statutes, they're supposed to be strictly construed against the state. The idea is not to expand taxing statutes so that they gather in new forms of activity to tax. That's, I think, where we're at in this particular case, is that what the department is trying to do is expand the scope of the taxing statute to tax an activity that clearly is distinguishable from other activities of which is taxing. Some of them you named, maybe they shouldn't be taxed. I don't know. I don't know enough, again, about going to batting cages, whether it should be taxed or not under the statute. Let me briefly address the issue of the memberships that is raised. The income derived from the membership fees should be attributable, if at all, to the amusement classification, not the rental classification. The membership fee includes 5 basic things: the privilege of reserving a lane, unlimited training time, 5 free range passes, a 5% discount on the purchase of retail items, and discounts on education and training courses. The record reflects that the main reason that people purchase the memberships is to get the privilege of reserving lane time, because in many cases, otherwise you'd have to wait maybe an hour or more to get access to the lanes, and also unlimited training time. The only feature that is retail here is the 5% discount. Now, I don't know about you, but I don't know when the last time a retail establishment announced they were giving 5% off as an inducement to really get customers to come in and buy retail goods. They simply don't. And the 5% is not designed to increase retail sales. The membership and this 5% is not designed to increase sales of retail. Primarily, this is an inducement to get people to use the range, which is arguably taxed, if it's taxed at all, under the amusement classification. So our position isn't that it's exempt. Our position is that if the court finds that shooting range is not taxable as amusement, then it should also find that shooting range's membership program is not taxable, because the income attributable to the membership program would be income under the amusement classification and not the retail classification. Thank you. If there's no other questions. Okay, thank you.
All right, thank you, counsel. The matter is deemed submitted. We'll issue a decision in due course. And thank you for your arguments and your briefing in this case.
Thank you.